I've been asked by council to make an announcement, which is for public consumption, obviously, being a public meeting and all. As most of you know, because you've been through this and been here, a proposed agreement of sale was received by me by Attorney Plummer, which is, quite frankly, a very good agreement of sale under normal circumstances. If you had a normal arm's length real estate transaction, this thing is textbook. It's very good. I've discussed it with Attorney Plummer. But we're not in an ordinary situation. And so therefore, rather than have it be very expensive, I took a page from my old oil and gas practice days, where people get oil and gas leases that they're being asked to sign, and nobody can afford to have a lawyer for them, paying them by the hour. Go line by line, word by word, comma through comma, with the attorney for the oil and gas company and get it all rewritten. So what you do in the real world to save money is you say, okay, I know what that document is saying, and I, the attorney for the landowner, am going to propose an addendum. And I'm going to get right to the heart of the points that I think are of concern to the landowner. I did that in this case. I went to the heart of what I thought were concerns for the borough and for the people and the citizenry of Coudersport. And I have proposed an addendum. And my recommendation is that if they're going to go forward with this project of putting the Arboretum up for sale, to basically have it be a package deal. Yeah, we'll agree basically with the agreement of sale that's been drafted by Attorney Plummer, but the high bidder, the successful bidder, whoever that might be, will have to, by being the high bidder, have agreed in advance to signing the addendum as well. And what the addendum does is, quite frankly, highly unusual. Number one, whoever the high bidder is going to be allowed to be able to be appointed as the agent for the borough of Coudersport. Kind of like a power of attorney, where the principal identifies who it is that gets to act for them. Most of your standard plain Jane powers of attorney in today's society allow the agent to commence litigation, to defend litigation. It's along those lines. Number two.
Dan?
No, I'm talking.
Okay.
Number two, whoever's the high bidder not only gets the right to say, I'd like to be agent, in which this addendum says they're going to be allowed to be agent. Whoever is the agent gets to nominate a person to be special counsel, to take the matter into court to seek court approval from the Orphans Court under the Act. We all know the Act, the one that's discussed in the Downington Borough case. And that special counsel will answer directly to both the agent and counsel. He does not answer to me as borough solicitor. I'm going to be kept informed, but I'm not reviewing it, I'm not critiquing it, I'm not passing upon what they're doing, but he will be. And this has been done many times. For example, if you have a bankruptcy case or you have a sort of a specialized thing, most of your municipalities, if you look back 40 years, have from time to time needed to appoint somebody as special counsel for whatever, bond counsel or whatever it is, because it's kind of a specialized thing. And I'll be very blunt. The majority has spoken, and I yield to the majority. I yield to the wisdom of your elected representatives. You can view it however you wish to view it. But I'm not going to make a very effective advocate. I might make a bunch of money, but I ain't in this for a lot of money. I'd have stayed in Chicago if I was trying to make a lot of money. I want the majority will to have its best chance at success. And having me be arguing to the Orphans Court that this is perfectly fine when my legal opinion is a matter of common circulation, does not cause me to be a particularly effective advocate. So if they're gonna do it with special counsel. I've distributed the addendum to Attorney Plummer. It's been distributed to council. I'm not sure anybody's really had a chance to fully digest it, because it took me a lot of thinking to figure out how to do this. On top of it, it's got a ton of indemnities. And it tries to indemnify the borough by whoever the high bidder is going to be saving, holding harmless, and indemnifying the borough from a ton of stuff. So if something odd crawls up or there's a repercussion, then the high bidder, the buyer, under the addendum, is going to be responsible. And I've recommended that the initial deposit that's in Mr. Plummer's document be a rather hefty one. I've already suggested it be somewhere in the $100,000 to $200,000 range to act as a secondary guarantee with respect to this indemnification business. And I'm also stating in it, under the addendum, that if it gets depleted, it's got to be made whole, because that money is supposed to be going to the borough. So, council, I've advised council, I think they have given what they passed upon before. They can either say, yep, we're ready to go, we've looked at over all we need, go forward, advertise it, let's get these bids in, I'm ready to do that. No dilly-dally. They've only just gotten it. I think you, the public, I've made it clear to Bev, to the borough manager, my addendum should be distributed to the public so you can examine it. Now, council may decide to table this so they have a chance to review these matters more fully and get further public input. I mean, this thing's been going on for 1,000,000 years. I don't know if another month is going to cause the planet to go into the sun. But I'm trying to step out of it to give the will of the majority a chance to see if they can get the job done. Because it's going to require, in my opinion, orphans court approval. And I don't know who all is going to be interested in bidding on it or who the high bidder will be. But I've tried to protect the people of Coudersport. So if we're going to do this, this is my suggestion. And I have given you the main points that are contained in my addendum. I'm not going to discuss the agreement of sale because it's a pretty straightforward document. There is one other thing. The agreement of sale proposes an exchange of property. I've also made it clear in the addendum that whoever is going to exchange the property has to agree in writing in advance to not insist upon a reversion unless, if the court feels that is a non-starter, basically. So, the language in the agreement of sale is somewhat nullified regarding this reversion business in the addendum. But I think that's a fairly fair synopsis of what it is that I've been working on. So, council's already had the chance in executive session. We discussed this topic because it involves litigation. We also discussed another topic which involved attorney-client privilege information. And so, fire away when ready. You got questions? You got comments?
Yes.
I'm ready to entertain them.
My question, I thought you said the name of this agent, whoever it was going to be. Did you mention a person or not?
No, whoever's the high successful bidder.
No. You were going to step aside and let another person be an agent.
Whoever's the buyer, the high bidder, gets to be the agent. The agent gets to nominate an attorney in good standing to be special counsel. that
So the
reports.
special counsel might be somebody Mr. Mueller recommends. So
Whoever's the high bidder can
he's the buyer and the seller and the, who knows what.
Who knows what?
Another question. The minutes of the June meeting were passed, and in the first paragraph, it said something about some way the property could be put up for bid. This is Mr. Plummer. Distributed a document entitled Request for Bids for Sale of Real Estate and for Proposal of Exchange of Property. I went in and asked the borough office, I'd like a copy of this proposal for bids that Mr. Plummer put out. They said they had no such thing. I asked one of the council members who said they had no such thing.
I told you it was the,
Well, I know you said it was the agreement of sale. An agreement of sale isn't the same thing as a request for bids.
Well, a request for bids is going to be very generic. It's going to be the standard thing you see when you advertise as a municipality, where the municipality is selling property to the high bidder. That document I have in draft form at my office, but the real meat in such a thing is what you're doing is you're making the high bidder agree in advance that they're going to sign the agreement of sale. If you have a copy of the agreement of sale, then you've got the real guts to the thing. But now you need to see the addendum. Because my recommendation is that they not agree to sell the property just pursuant to the agreement of sale, but that the agreement of sale has to have the addendum, and the addendum makes it very express that it is understood by the parties that this addendum is attached to an agreement of sale which relates to the sale of the portion of land owned by seller on which is currently situated an arboretum, and it is the intent of the parties that the terms and conditions of this addendum shall control and be conclusive in the event that there is any discrepancy or difference of any nature between that set forth in the agreement of sale and that set forth in this addendum. This is because most of the terms and conditions of the agreement of sale are satisfactory to the parties, but there are some changes and modifications which are set forth in this addendum, and it is intended that this addendum should conclusively control in the event of such situation.
Well, we now have filed articles of incorporation, 501c3, to challenge any sale. And one thing we challenge, this is a photo of the entrance of our arboretum. This is a photo of the entrance to the arboretum that is being proposed. We don't care what Tom, John Wright, whatever do with this document. We are going to go to court saying that the Downingtown decision is in agreement with what we know to be true, and that is that the arboretum can't be sold even with some ridiculous thing like this. I've got a lot of beautiful pictures of the Coudersport Arboretum. I only need one of these, because if you turn it to this side and take a photo, and turn it to this side and take a photo, it's all the same. You might have 2 or 3 pieces of clover in that little batch of ground, but as far as we're concerned, we'll make my life simpler. I call this the Todd Husson, John Wright Arboretum. If you want that, fine, but we don't want any part of that.
The addendum recognizes that concern, recognizes that situation, and it clearly makes any sale conditioned as a condition preceding. That it first has to be approved by the Orphans Court of the Court of Common Pleas of Potter County. And so no sale shall take place until the court has spoken. So your efforts will not go in vain. You will have a forum in which to address that, sir.
There also needs to be a subdivision, I understand.
This is addressed in the documents.
It's addressed in Mr. Plummer's part of the document.
I thought it was adequately addressed. I think it basically makes it clear that the buyer will be responsible for getting it subdivided, and quite frankly, given what I've seen, I see no real obstacle with respect to subdivision. What I really see is an issue concerning the Downingtown Borough case.
Absolutely.
And basically it says, give her a whirl, let a judge decide.
Well, and then let the subdivision folks decide as well.
True, but
There's a ways to go here, I do believe, but we are prepared to challenge it.
well, that's your
in
right
court.
as a citizen of this country and of this county. And again, there's no effort to dodge around this. It's clear that this is a controversial issue, and I think we've made it clear that it's going to be taken to the court, and the court shall decide, and I have total confidence in the judicial system, that everyone will be given a fair hearing.
A last statement from me. You had said in the minutes that I was quoting that Mr. Plummer had to get the court's approval. In my reading of Downingtown, the first thing that should be done before something's bid out for sale is to get that it is up to you, solicitor for the governing body, to get the approval of the orphans court.
I think it's 6 of one, half a dozen of the other. I think it's perfectly legal to have an agreement of sale that makes the closing conditional upon getting an approval from the orphans court, and I feel very confident that the addendum protects the rights of the public to basically have a fair hearing on the matter.
Thank you.
Mr. Plummer, I would call on you, if you would please, to at least indicate whether you've had a chance to review the addendum.
Yes, I have reviewed the addendum. My client has reviewed the addendum, and it is more strict and stringent than the draft that I put, but we will agree to be bound by it.
Thank you, sir.
If we are fortunate enough to be the high bidder.
Thank you. Next person, yes, ma'am.
Is there a time frame that council is looking at as far as how long the bids will be out? Is it a 30-day process, a 60-day process? Is that?
Well, first they have to decide if they want to put it out to bid with the addendum, and they can decide to table it and decide it next month, but if they decide to do it by tonight, then I'm thinking we ought to be able to have this ready to open bids either at the meeting in September or at the latest, the meeting in October, but then that's still going to be conditioned on court approval. I can't imagine it taking longer than the meeting in October to open the bids and award a bid.
But my question is, how long will the due date for bids to be in? Is it a 30 days to get your bid in, or?
It's like, I forget, to be honest.
I
It's like
think
14 days.
I think the statute requires 11 days, and any number bigger than
Yeah.
11 works.
Yeah, but that's what I'm saying, it's gonna be either in the September meeting or the October meeting, if council decides to continue in that direction.
Well, I'm presuming that they won't,
We'll meet with all statutory requirements in the bidding process.
won't vote on something that they haven't read yet, but will this be made available to the public?
Yes,
Like, how soon?
now,
Great. Thank you.
yes.
One thing y'all gotta remember is y'all took an oath to uphold the Constitution, to uphold the law and defend the Constitution. The Constitution in Pennsylvania says that this would be an illegal sale. Therefore, you would be oath breakers. Think about it, that's all.
I just have one thing to say also, that what Dr. Wagner said about using the word "we." That is a separate group from the Arboretum Association. That is the Friends of the Arboretum. There are actually two separate groups. Actually, there's 4 separate groups that will be involved in this now.
Well, if you read the Downingtown Borough, there's probably 17 groups.
Yeah, well, I'm just saying that I think everyone might think this is the Arboretum in itself. There's
recognize that.
a couple other groups been formed.
That's the beauty of a free society.
Oh, yeah.
Independent judiciary, people get a fair hearing.
The one is a re-election group also.
I think we've concluded this phase. I think we should move on to other public comments.
Will there be a minimum bid?
No, because they can reject any and all bids. So let the highest bidder, if it's good enough, then take it. If it ain't good enough, reject it.
Are there copies available now? You said that we could have them now?
I got a copy right here of the addendum. You already have the agreement of sale.
Well, no, I don't.
Well, you're not gonna stop the meeting. You do photocopy. If that's what it is.
I'm just saying what you said. You said it's
You want
available
it?
now.
Here's the addendum. I'll tell you something, you can bank on it. Making sure you're not out of the loop. Here's the agreement of sale.
Super,
So is that close to now?
yeah.
Thank you.
Photograph those before we leave.
Does that conclude the visitor requests and comments?
I would like to mention something about the Arboretum.
You know, it's out of